Welcome to Justipedia. Today, let's break down the concept and elements of obligation. Hit subscribe, your next review or video is coming up.
Article 1156. An obligation is a juridical necessity to give, to do or not to do. Obligations have the following elements. Active subject, which is the possessor of a right, he in whose favor the obligation is constituted. Passive subject, who has the duty of giving, doing, or not doing. Object or prestation that may consist of giving a thing, doing or not doing a certain act. And the efficient cause, which is the reason why the obligation exists.
There are various bases for the classification of obligations. First, from the viewpoint of sanction, is the civil or perfect obligation as defined in Article 1156. Natural obligation is the duty not to recover what has voluntarily been paid although payment was no longer required. Moral obligation, in which the sanction is conscience or morality, or the law of the Church. From the viewpoint of subject matter, is the real obligation, which means the obligation to give, and the personal obligation, which is obligation to do or not to do. From the affirmativeness and negativeness of the obligation is the positive or affirmative obligation, that is the obligation to give or to do, and the negative obligation, which is the obligation not to do, which naturally includes not to give. From the viewpoint of persons, obliged is unilateral, where only one of the parties is bound, and bilateral, where both parties are bound. Bilateral obligations may be reciprocal or non-reciprocal, in which it pertains to performance by one is non-dependent upon performance by the other.
Article 1157. Obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Law is like the duty to pay taxes and to support one's family. Contracts is like the duty to repay a loan by virtue of an agreement. Quasi-contracts is the duty to refund an overchange of money, while acts or omissions punished by law is like the duty to return a stolen carabao. Lastly, the quasi-delicts is like the duty to repair damage due to negligence. Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen, by the provisions of this book. Art. 1159. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Neither party may unilaterally and upon his own exclusive volition escape his obligations under the contract, unless the other party assented thereto, or unless for causes sufficient in law and pronounced adequate by a competent tribunal. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17, of this book. A quasi-contract is that juridical relation resulting from a lawful, voluntary, and unilateral act, and which has for its purpose the payment of indemnity to the end that no one shall be unjustly enriched or benefited at the expense of another. The two kinds of quasi-contracts are negotiorum gestio and solutio indebiti. Negotiorum gestio takes place when a person voluntarily takes charge of another's abandoned business or property without the owner's authority. Solutio indebiti takes place when something is received when there is no right to demand it, and it was unduly delivered through mistake. The recipient has the duty to return it. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177, and of the pertinent provisions of Chapter 2, Preliminary Title, on Human Relations, and of Title 18 of this book, regulating damages. Article 100 of the Revised Penal Code. Civil liability of a person guilty of felony. Every person criminally liable for a felony is also civilly liable. The civil liability arising from a crime includes restitution, reparation of the damage caused, indemnification for consequential damages. Article 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. A quasi-delict is a fault or act of negligence, or omission of care, which causes damages to another, there being no pre-existing contractual relations between the parties. Negligence is the failure to observe, for the protection of the interests of another person, that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. The test in determining whether a person is negligent is this: would a prudent man, in his position, foresee harm to the person injured as a reasonable consequence of the course about to be pursued? If so, the law imposes a duty on the actor to refrain from that course, or to take precaution against its mischievous results, and the failure to do so constitutes negligence. Reasonable foresight of harm, followed by the ignoring of the admonition born of this provision, is the constitute fact of negligence. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. This article deals with the first effect of an obligation to deliver a determinate thing or the duty to exercise proper diligence. Unless diligence is exercised, there is a danger that the property would be lost or destroyed, thus rendering illusory the obligation. However, the law requires extraordinary care in common carrier. Nature and effect of obligations. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. This article deals with the first effect of an obligation to deliver a determinate thing, as distinguished from a generic thing, or one of a class, namely, the duty to exercise proper diligence. Unless diligence is exercised, there is a danger that the property would be lost or destroyed, thus rendering illusory the obligation. However, the law requires extraordinary care in common carrier. Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. If there is no term or condition, the obligation to deliver arises then from the perfection of the contract. If there is a term or a condition, then from the moment the term arrives or the condition happens. Article 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obliger delays, or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for fortuitous event until he has effected the delivery. When the debtor fails to comply with his obligation, the creditor may demand specific performance, or compliance, of the obligation, demand rescission or cancellation, or demand damages either with or without either of the first two. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Accessories are those joined to or included with the principal for the latter's better use, perfection, or enjoyment. Accessions, additions to or improvements upon a thing. These include alluvium, soil gradually deposited by the current of a river on a river bank, and whatever is built, planted, or sown on a person's parcel of land. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. The first sentence of the article deals with a positive personal obligation, to do. A thing may be ordered undone if made poorly or if the obligation is negative one. Article 1168. When the obligation consists in not doing, and the obliger does what has been forbidden him, it shall also be undone at his expense. This article refers to a negative personal obligation. As a rule, the remedy is the undoing of the prohibited thing plus damages. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. 1. When the obligation or the law expressly so declares, or 2. When from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or 3. When demand would be useless, as when the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Article 1170. Those who in the performance of their obligation are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. Grounds for liability in the performance of obligations are fraud or deceit or dolo, and with intentional evasion of fulfillment, negligence, default or mora if imputable to the debtor, and lastly, violation of the terms of the obligation unless excused in proper cases by fortuitous events. Kinds of damages: moral for mental and physical anguish, exemplary, corrective or to set an example, nominal to vindicate a right, when no other kind of damages may be recovered, temperate, when the exact amount of damages cannot be determined, actual losses as well as unrealized profit, liquidated, predetermined beforehand, by agreement. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Remember that according to time of commission, fraud may be past or future, liability for past fraud may be waived. This is not so for future fraud, while dolo causate is so important a fraud that vitiates consent. Allowing therefore annulment, dolo incidente is not important. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts, according to the circumstances. Note that gross negligence can never be excused in advance, for this would be contrary to public policy. Simple negligence may in certain cases be excused or mitigated. Stipulations on negligence must be strictly construed against the party situated in a higher or more advantageous position. There are three kinds of culpa: the culpa contractual, that which results in a breach of a contract; culpa aquiliana, which results in civil negligence; and culpa criminal, which results in the commission of a crime or a delict. Article 1173. The fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Under the Code, the following kinds of diligence are required: that agreed upon by the parties in the absence of agreement upon the parties, that required by the law, particular provision, such as the responsibility of a common carrier, is extraordinary and lasts from the time the goods are placed in its possession until they are delivered actually or constructively, to the consignee or to the person who has a right to receive them. In the absence of legal provision, that expected of a good father of a family. Art. 1174. Except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. General rule for fortuitous events is no liability for a fortuitous event, that which could not be foreseen, or which even if foreseen, was inevitable. However, there are exceptions. When expressly declared by the law, such as when the possessor is in bad faith or is in default. When expressly declared by stipulation or contract. When the nature of the obligation requires the assumption of risk. Art. 1175. Usurious transactions shall be governed by special laws. Usury is contracting for or receiving something in excess of the amount allowed by law for the loan or use of money, goods, chattels, or credits. In other words, usury is the exaction of excessive interest. Article 1176. The receipt of the principal by the creditor, without reservation with respect to the interest, shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installment, shall likewise raise the presumption that such installments have been paid. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. General rights are transmissible except if the law provides otherwise, if the contract provides otherwise, if the obligation is purely personal.